You know that familiar low-level anxiety you get when you're going through a background verification check for a new job?
Oh, yeah, everybody knows that feeling.
Right. Like you've already got the offer, you're thrilled about the new salary, but then um, you have to start digging up old offer letters, experience certificates.
Searching through your inbox from 10 years ago.
Exactly. Or trying to get a relieving letter from a manager you literally haven't spoken to in 5 years.
It's the worst.
It really is. For most of us, it just feels like another tedious administrative hurdle, just a bunch of paperwork you submit to HR so you can finally get your company laptop and like actually start working.
Yeah, it just feels like a box to check.
But what happens when that routine, seemingly harmless HR document from a background check triggers a full-blown criminal prosecution?
Which sounds insane, I know.
It totally does, because on July 2, 2026, the Karnataka High Court actually had to step in and stop exactly that from happening to a doctor. And this case exposes a massive blind spot that you probably have right now about your own company's paperwork.
Yeah, it sounds almost absurd to think about getting arrested over a background check. But it is happening. What this judgment does is completely shatter how we traditionally think about employment paperwork.
Right.
It transforms it from this mundane administrative chore into a massive corporate liability.
Okay, let's unpack this, because
Yeah.
the details of how this actually unfolded are wild. And it completely reframes those standard PDFs we just, email around every single day.
Oh, absolutely.
We are looking at a scenario where HR documents are no longer just files in a cabinet somewhere. They're electronic records armed with immense legal firepower.
They really are. And I think it's crucial to understand that our mission in this deep dive today isn't just to dissect a very messy legal squabble between two hospitals.
Right, it's bigger than that.
Much bigger. What this case actually reveals is the foundational trust architecture of every modern organization you interact with.
Trust architecture, I like that phrase.
Yeah, we're talking about the very scaffolding that holds professional relationships together in the digital age. And, well, what happens when that scaffolding just completely collapses in a courtroom?
Wow. Okay, so let's get right into the facts of this case. At the center of it, we have this highly distinguished oncologist.
A very successful doctor.
Very. This doctor had worked at Manipal Hospital for nearly 19 years. That is, 2 decades of treating patients, building a massive career, and then in 2022, the doctor resigns.
Which is pretty standard.
Right. And the source material specifically notes this was an amicable split. The doctor was formally relieved with appreciation and then just moved on to a higher position at a rival institution, Astor Hospital.
I mean, that is a completely standard, even ideal career progression. 19 years is a massive tenure for anyone.
It's basically unheard of these days.
Right. And leaving on good terms with an official relieving letter is exactly how you want that chapter to end before, stepping into a bigger role.
But then, just 3 months later, the plot twists completely. Manipal Hospital receives an email from a third-party background verification agency called Dataflow.
Which is very common, right? Astor Hospital was just doing their due diligence.
Exactly.
Yeah.
But attached to this email is an experience certificate, purportedly issued by Manipal Hospital for this doctor, and it bears the signature of a Manipal official.
Okay, so far so normal.
But here is where the entire professional relationship just completely breaks down.
Yeah.
Manipal looks at this document, they look at the signature, and they claim it is forged.
Just right out of the gate, forged.
Yes. And they don't just send a cease and desist letter or an angry email to the doctor.
Which is what you would expect.
Right. They bypass civil remedies entirely and initiate criminal proceedings by filing a private complaint.
That is just an enormous and aggressive escalation.
It's going 0 to 60.
Literally, we are moving from what could be a potential administrative error or maybe a miscommunication between recruiters straight into the realm of the penal code. You have a major hospital trying to mobilize the criminal justice system against its own former star doctor.
It's wild. And the police actually investigate this complaint. So after looking into it, the police submit what's called a B report in the Indian legal system.
Right, the B report.
Yeah. Now, for those unfamiliar, a B report essentially means the police have investigated the allegations and concluded that no criminal offense appears to have been made out.
Exactly.
They are basically telling the court, look, we looked under every rock, and there is just no crime here to prosecute. Case closed, right?
You would think so.
No. Manipul is dissatisfied with this conclusion, so they file a protest petition.
And a protest petition is a crucial legal mechanism here. It is the complainant's way of formally objecting to the police's findings.
Ah, okay.
They're essentially telling the magistrate, hey, the police missed something, or they evaluated the evidence incorrectly. You need to look at this again.
And because of this protest petition, the magistrate actually takes cognizance of the case and issues a formal summons to the doctor.
Wait, what does taking cognizance actually mean in this context?
Well, it's a specific legal threshold.
Is that the judge basically saying, I think the police are wrong, let's go to trial?
Not exactly let's go to trial, but it's the critical step right before a trial. Taking cognizance means the magistrate has actively applied their judicial mind to the facts presented in the complaint.
Okay.
And they decided, yes, there are sufficient grounds here to proceed with the legal machinery.
Oh, wow.
So by issuing that summons, the magistrate is forcing the doctor to physically appear in a criminal court as an accused person.
Think about the psychological toll of that. You are an oncologist, you've moved on to a new job to treat cancer patients, and suddenly you are being dragged into criminal court over a piece of HR paperwork that some background verification agency handled.
It's incredibly disruptive. So, understandably, the doctor refuses to just take this lying down and challenges these proceedings, pushing this all the way up to the Karnataka High Court.
A smart move.
And this is where Honorable Justice M. Nagaprasana steps in to evaluate what has just happened.
And the High Court's intervention here is just definitive. The court quashes the proceedings entirely.
You just threw it out.
Exactly, which means they invalidate and throw out the magistrate's order. The exact quote from Justice Nagaprasana is striking.
Oh, I have it right here. He stated, such cases should not be even permitted to be tried. The concerned court has erred in taking cognizance of the offense against a doctor and issuing summons without even looking at the documents which were produced at the time when the B report was filed.
Right.
The judge is basically saying the lower court didn't even read the room, or, more importantly, didn't even read the police's evidence before dragging this doctor into a criminal proceeding.
Yeah, the High Court was very clear that allowing the proceedings to continue would be an abuse of the process of law and a massive miscarriage of justice.
Absolutely.
But what is truly remarkable is the balancing act the court performed immediately after throwing the case out.
Yes, the oral advice given during the hearing. The court told the hospital, allow doctors to treat patients. Do not drag them into your inter-hospital disputes.
It's such a grounding statement.
It really is. It refocuses everyone on what actually matters, which is human health care, rather than corporate ego.
And the court went one step further in maintaining that balance. The doctor, understandably furious about this whole ordeal, wanted to file retaliatory proceedings against Manipul Hospital for malicious prosecution.
I mean, I would too.
Right. They wanted to sue the hospital for dragging them through the mud, but the court refused to permit it.
They intentionally cut off the cycle of revenge. By protecting the doctor from the unwarranted trial, but also blocking the retaliatory lawsuit, the court deliberately prevented this endless toxic cycle of litigation.
That is the absolute hallmark of a pragmatic judiciary. They de-escalated a situation that was spiraling completely out of control and essentially forced both parties to walk away.
Yeah, I totally get the legal resolution, but I have to ask this on your behalf, because if you're shaking your head right now, I am too.
It's a lot to take in.
The magistrate's initial summons feels like such a knee-jerk reaction. But looking at the hospital's behavior, why would a massive, prestigious healthcare institution go absolutely nuclear over a single experience certificate?
It seems like an overreaction.
Right. Why jump straight to a criminal complaint instead of just picking up the phone, calling Astor Hospital, and saying, hey, there's a weird document in this file, let's sort this out?
Well, if we connect this to the bigger picture, organizations go nuclear because they have learned, often the incredibly hard and expensive way, that casual documents can absolutely explode in a courtroom years later.
Just completely blow up in their face.
Exactly. A single disputed signature isn't just an administrative error to a corporate lawyer. It is a massive existential liability.
Wait, really? A standard HR experience certificate is an existential threat?
It can. To understand why a corporate entity reacts with such overwhelming hostility to a disputed signature, we have to look at the historical precedent mentioned in our source material.
Okay.
We have to rewind nearly 2 decades to the infamous You Paid Satyam controversy.
Set the scene for us. How does a 20-year-old case explain a modern hospital dispute?
So, between 1997 and 2002, a company called UPaid engaged Satyam Computer Services for a major software development project.
Right in the middle of the early tech boom.
Exactly. And it was a massive $10 million deal. Notably, because UPaid didn't have all that cash on hand at the time, they paid Satyam partly in company shares.
Okay, that makes sense.
Now, the technology they developed together was highly innovative and extremely valuable. Later on, UPaid wanted to formally patent this technology.
Right, to protect it.
And to do that, they needed intellectual property assignment documents.
Well, because when a software developer writes code for a company, the developer inherently owns the copyright to that code unless they explicitly sign a legal document relinquishing those rights to the company.
Precisely. You need it in writing. So UPaid needed the physical signatures of these specific software developers at Satyam who actually built the tech, officially transferring the rights to UPaid.
Got it.
So Satyam went out, gathered those signatures from their employees, and provided the assignment documents to UPaid.
Everything seems fine so far.
Right. UPaid takes those documents, successfully gets the patent, and fast forward to 2005, they realize that telecom giants Verizon Wireless and Qualcomm are allegedly using their newly patented technology.
Oh boy.
So UPaid files a massive, high-stakes patent infringement lawsuit against them.
Here's where it gets really interesting.
It does. During this high-stakes litigation, a catastrophic complication arises. Two former Satyam employees who had worked on that original 1997 project had since left the company.
Okay.
And one of them was now working for Verizon.
Wait, so the guy who helped build the tech is now working for the company being sued for stealing the tech?
Yes. And this former employee, now sitting at Verizon, looks at the intellectual property assignment document that Satyam had originally provided to UPaid, looks at the signature line and says, "That is not my signature. I never signed that document."
Wow. So in the middle of a massive lawsuit against Verizon, an employee of Verizon says the foundational document giving UPaid the right to sue them in the first place is a forgery.
That's exactly what happened. And think about the mechanical legal consequences of that claim.
Domino effect.
Completely. If that signature is forged, the assignment is invalid. If the assignment is invalid, UPaid doesn't actually own the intellectual property.
Right.
And if UPaid doesn't own the property, they have absolutely no legal standing to sue Verizon.
Wow.
The entire multi-million-dollar lawsuit, years of legal work, and the ownership of the patent itself all hinged on the authenticity of a single signature from one mid-level software developer.
The entire house of cards rests on one line of ink. That is terrifying.
The fallout was staggering. The single, vehemently disputed signature on an employment-related assignment document derailed everything.
I can imagine.
It became the absolute focal point of the litigation, dragging Satyam into a massive legal mess regarding fraud and forgery. That litigation ultimately culminated in a settlement reportedly involving nearly $70 million.
$70 million.
Yeah.
Because of one signature on a piece of employee paperwork. That completely recontextualizes things.
It really changes your perspective, doesn't it?
It's like, imagine you write down a mundane grocery list, right? Just milk, eggs, bread. You throw it away.
Right.
And 10 years later, that exact piece of paper is entered as the murder weapon in a courtroom thriller. You never intended for it to have that kind of weight when you scribbled it down.
That is a brilliant way to frame it. The core takeaway from the UPaid Satyam case and why it heavily influences corporate behavior in our hospital case today is that whether the signatures were ultimately proven to be forged or not is almost secondary.
The damage is already done.
Exactly. The real lesson is the enormous evidentiary significance of employment documents once they cross the threshold of a courtroom.
So the moment a lawyer submits it into evidence, it stops being HR paperwork and instantly transforms into a sworn artifact.
Bingo. A document casually prepared today, maybe rushed by a stressed recruiter, maybe quickly signed off by a manager trying to clear their inbox before a long weekend,
We've all been there.
can become the single deciding factor in a multi-million-dollar litigation years down the line. That is why organizations panic and go nuclear when they see a document floating around with their name on it that they cannot explicitly verify.
Okay, I get the panic now. But if a disputed signature can trigger a $70 million lawsuit, you have to wonder how, over 20 years later, Menopause Hospital couldn't definitively prove whether they actually signed that experience certificate.
A great question.
Right. Like, we aren't relying on dusty filing cabinets anymore. How does a modern digital document just lose its chain of custody like that?
That is the exact missing governance perspective our source material dives into. The High Court rightly focused on stopping the unfair criminal trial. But from a purely forensic and academic standpoint, the life cycle of that specific document is a total mystery.
How does an investigator even look at a digital mystery like this? It's not like they can dust a PDF for fingerprints.
Well, our source text lays out a fascinating series of academic questions to demonstrate how a digital investigation works. And we should clarify upfront that these are purely academic questions. There is no proof of any wrongdoing by Dataflow or any other participant here.
Right, just a theoretical exercise.
Exactly. But a forensic investigator wouldn't just look at the PDF. They look at the digital exhaust, the metadata. They would first ask, did an original physically signed experience certificate ever actually exist in the physical world?
Because if there was never a piece of paper, you're immediately looking for a digital trace.
Second, was the document generated electronically specifically for the purpose of this background verification?
Okay, how would they know that?
An investigator checks the server logs. They look to see if that exact file was pulled from a secure legacy HR system where it had been sitting for months, or if the metadata shows it was newly created on a desktop at, like, 2:00 p.m. the day before it was emailed.
Oh, that makes sense.
Yeah.
The creation tags would give away a newly fabricated document instantly.
What about the signature itself, though?
That leads to the core forensic question. Was the signature simply reproduced from another legitimate record?
Meaning someone just copied and pasted it.
Yes. We see this constantly in corporate environments. Someone needs to get a form out the door quickly, so they copy and paste a JPEG image of a director's signature from an old email or company memo, and they just paste it onto the new PDF.
Oh, man. So relying on a JPEG of a signature is essentially like taking a photo of your house key and expecting it to unlock your front door.
I love that analogy.
It looks exactly like the key, but it has absolute no functional security. We need the cryptographic equivalent of the actual metal key. That hits the nail on the head. A pasted JPEG has no security. It doesn't bind the identity of the signer to the document.
Right.
And that brings up the final investigative question. Was this document created by someone attempting to facilitate the background check quickly, completely oblivious to the legal consequences of technically committing forgery?
Just trying to be helpful, but making a massive mistake.
Exactly. Did the prospective employer, Astor Hospital, specifically require this exact format of a certificate, forcing a recruiter's hand to hastily produce it?
It's a chain of custody nightmare. Every link in that chain, the recruiter, the background agency, the manager, is a potential point of failure.
And this is where the legal framework brutally catches up with casual technology habits. This isn't just about violating a company policy anymore.
No.
No. Over 25 years ago, the Information Technology Act of 2000 legally validated electronic records in India. They carry the exact same evidentiary weight as physical paper.
Wow.
And more recently, the Digital Personal Data Protection Act, or the DPDP Act of 2023, firmly classifies employee records as personal data.
Wait, let me stop you there, make sure I understand the gravity of this. Are you telling me that when I receive a simple PDF promotion letter in my inbox, or, one of those automated relieving letters when I leave a job, the law views that PDF with the exact same legal weight as a signed multi-million-dollar financial contract?
The law makes absolutely no distinction between the gravity of a financial contract and an employment record.
That is wild.
They are both legally binding electronic records capable of being presented as evidence in a court of law. And because they contain personal information, the DPDP Act mandates they require strict legal governance.
Okay.
Which brings us to the DGPSI perspective.
Yes, I saw that acronym in the source material. What exactly is the DGPSI and who made it?
So the DGPSI stands for the Data Governance and Protection Standard of India. It is a comprehensive, practical compliance framework designed by experts to help organizations actually implement the broad, complex requirements of laws like the DPDP Act.
So it's like a guidebook.
Exactly. It translates legal theory into actionable security protocols.
Okay, so what does this standard actually say about our casual HR PDFs?
It explicitly mandates that HR documentation deserves the exact same rigorous governance standards that banks apply to financial records.
No more treating them like casual paperwork.
Precisely. Organizations can no longer treat these as just administrative chores. We are talking about experience certificates, relieving letters, employment verification responses, background check reports, promotion letters, and literally any digitally signed approvals.
Everything.
Every single one of these carries legal consequences and must be secured.
So what does this all mean? If you're listening to this and you run a team or you're an HR director or an executive, how do we stop the bleeding? How do the organizations we work for actually fix this before they end up facing off in the high court?
Well, first, we have to address the specific context of hospitals, as heavily highlighted by the judge in this case.
Because they're in healthcare.
Right. Hospitals carry a higher fiduciary responsibility than an ordinary commercial enterprise. They occupy a unique, sacred position of trust in society because they deal directly with human life and public health.
The stakes are literally life and death. So a hospital's primary duty is to the patient, not their corporate pride.
Therefore, the court sent a massive warning shot that professional differences between hospitals, competing doctors, or recruiters must be handled with immense restraint.
That makes sense.
Unless you have ironclad, compelling forensic evidence of criminal misconduct, you do not weaponize the criminal justice system to resolve a competitive employment dispute.
You don't use the local police as your outsourced HR enforcers.
Exactly. Now, for practical solutions that apply to every industry, our source outlined several key actionable takeaways from Navi, a leading expert in cyber law and data governance.
Okay, lay them on me.
The very first shift has to be cultural. Organizations must stop treating HR documents as administrative chores and start treating them as legally significant electronic records.
It seems to me that the easiest fix for a lot of this is just banning physical signatures entirely and making everything run through a secure web portal. Is that what the standard recommends? Or is it more complicated than that?
A secure web portal is a massive step in the right direction, and it aligns perfectly with the standard's push for true digital authentication.
So no more JPEGs.
Right. Organizations must progressively replace those scanned JPEG images of signatures with actual digital cryptographic signatures.
And how does that work?
A cryptographic signature binds the specific user's identity to the document at an exact timestamp. And if anyone alters a PDF even slightly after it's signed,
Even just changing one word.
even just a space, the signature mathematically breaks, making tampering incredibly obvious.
So you have a perfect audit trail of exactly who approved it and when.
Yes. You also need documented procedures for background verification. Organizations must define exactly who is explicitly authorized to issue responses, how the authenticity of a request is verified before a document is sent, and how the audit trails of that communication are preserved for years.
Wow. Okay, so no more rogue managers giving informal glowing references on official company letterhead just to help out a former colleague.
It's just too risky now.
But, you can buy all the fancy cryptographic software in the world, and if an HR rep just takes a screenshot and emails it out of habit because they're in a rush,
Yeah.
you're back to square one.
Which is why the technological fix is useless without the human fix.
Right.
Cyber law awareness training has to extend far beyond the IT department. HR personnel, recruiters, administrators, and even vendor managers who handle outside contractors, they all routinely handle electronic records that may later become legal evidence.
They're the ones actually sending the emails.
They are the front line of legal defense, and they need to understand the cyber law implications of their daily tasks.
But that requires entirely different departments talking to each other. Usually, IT handles the software and HR handles the people, and they rarely cross over unless someone's laptop breaks.
The standard demands breaking down those exact corporate silos. Data protection officers, chief information security officers, and HR heads must work together collaboratively.
A unified front.
Yes, employee records are personal data under the TDP Act. Governing their integrity, confidentiality, and lawful disclosure is a legally mandated team effort.
That makes a lot of sense.
What's fascinating here is a profound quote in the source material that sums this dynamic up perfectly. It says, "Many cyber incidents are not failures of technology, they are failures of governance. Technology merely exposes them."
Oh, that is so true. That captures the entire issue. When a forged signature or a disputed document ends up derailing a trial, it's not just a printer error or a software glitch.
No, not at all.
It is a fundamental breakdown in how the organization governs its own internal truth.
Yes.
It is a massive failure of their trust architecture. And that is really the enduring lesson of this entire deep dive.
Absolutely.
We started with a doctor trying to avoid an unwarranted criminal trial over a simple background check. But what we really uncovered is a blaring wake-up call for every single business operating today.
The High Court didn't just protect an individual doctor. They issued a structural warning about how we are failing to manage digital trust in the modern workplace.
Because when these seemingly mundane documents are questioned before a judge 20 years from now, The issue isn't just going to be what the piece of paper says.
No.
The real question is whether the organization can actually prove its authenticity, its integrity, its complete provenance from creation to the courtroom.
Exactly.
Can they prove human accountability for that specific digital file? Because ultimately, every HR document is also a cyber law document.
And if an organization cannot definitively answer those questions of provenance and authenticity using metadata and cryptographic proof, it is their governance process that needs a total overhaul, not just their background check software.
Which leaves us with a pretty intense thought to chew on as we wrap up.
Let's hear it.
We've just spent this time establishing that every routine HR document is now permanent, high-stakes legal evidence that requires strict human accountability and unbreakable audit trails.
It's an incredibly heavy burden of proof for any company to maintain.
Yeah. So, what happens when your company inevitably starts using AI to automatically generate and sign off on your annual performance reviews or your exit interviews or your employment verifications?
Oh, wow. Yeah.
When a machine inevitably hallucinates a negative detail on your official, legally binding employment record, who exactly goes to court when you dispute it?
That raises a massive legal question about automated governance, and it's one we're absolutely going to see play out in the legal system very soon.
I have a feeling we'll be doing another deep dive on that exact lawsuit in a few years.
I wouldn't be surprised.
Well, thank you so much for joining us on this deep dive. Next time you're handed a piece of routine HR paperwork to sign, I highly encourage you to look a little closer at what you are actually putting your name on and how that signature is being captured. Catch you next time.